morning, we're here this morning to hear oral arguments in the case of Deborah Kalbaugh versus William Kalbaugh. Each party will have 15 minutes in which to present their case. The appellant may have to reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the time and I will keep you apprised of the passage of time. We are being visually and audibly recorded, so to be posted online, so please try to remain behind the podium as much as possible. We've read your briefs and we're ready to proceed when you are.
Thank you. Good morning.
Morning.
May it please the court. My name is John Torilla, and I represent the appellant, Mr. William Kalbaugh. Your Honor, the judgment entry from the trial court that we are appealing was based on a void and unenforceable judgment entry. Both the magistrate's decision and the trial court's judgment entry of January 19, 2016, and their respective decision and entry of June 3, 2016, upon the objections, were based upon a judgment entry that was entered by the trial court on August 26, 1996. And you can find the support for that claim in the magistrate's January 19 decision at findings of fact 16, 17, and 19. My apologies, Your Honor, I would like to reserve 4 minutes of my time. Thank you. Now, the judgment entry of August 26, 1996, I have claimed is void and unenforceable. This proposition is set out clearly in Mr. Kalbaugh's opening brief at pages 16 to 22. As this court certainly knows, a trial court may not modify the property division of its decree of divorce unless it retains jurisdiction to do so. Statutory prohibition of 3105.171I, and of course law of the case Cameron versus Cameron, among others, at the opening brief of the appellant, page 15. Moreover, this prohibition against modifying a division of pension benefits is considered jurisdictional. Again, appellant's opening brief, pages 8 and 15, the case of Butcher versus Butcher. As a jurisdictional matter, this aspect cannot be waived. Burkhart versus Burkhart, appellant's opening brief, page 15, footnote 2. Referring the court to the defendant's post-hearing brief at the trial court level, Exhibit E, the court's decree of divorce, entered on November 16, 1995, clearly did not reserve jurisdiction to modify the property division. When you go to the judgment entry that was entered on August 26, 1996, which was entered for purposes of enforcing a qualified domestic relations order and to allocate the division of pension benefits, that entry substantially altered and modified the division provided for by the decree of divorce. How so? Referring the court to the defendant's post-hearing brief, Exhibit F, Section 1A. There, the judgment entry discarded the agreed values of Mr. Kalbaugh's OPF and based Mrs. Kalbaugh's entitlement to the values that would exist when Mr. Kalbaugh began receiving benefits, not as of the date of the divorce, which is what the decree provided. Under Section B at page 2, it added that Mrs. Kalbaugh's interests were to be enhanced by post-divorce cost of living adjustments, not in the divorce decree. On Section 4 at page 3 of that entry, it required Mr. Kalbaugh to insure Mrs. Kalbaugh's interests with a $100,000 term life insurance policy, nowhere to be seen in the decree of divorce. Again, Section 4, page 3 of that judgment entry imposed a lien on Mr. Kalbaugh's probate and non-probate assets, another provision not in the decree of divorce. Without pale, Your Honor, these substantial and material modifications to the decree of divorce without jurisdictional reservation to do so, render that judgment entry of August 26, 1996 void and unenforceable. As a consequence, the trial court's decision here that is based upon that judgment entry is similarly void. Now, let me comment to the notion that Mr. Kalbaugh may have waived his objections. With all due respect, Your Honor, I refer the court's attention to Mr. Kalbaugh's opening brief at pages 11 and 12, and his reply brief at pages 5 and 6. Those are references to the very objections that Mr. Kalbaugh entered at the trial court level. Notwithstanding, Mr. Kalbaugh's argument is a jurisdictional challenge, and as a matter of law, cannot be waived. Now, it has been suggested that this appeal may in fact be premature. Once again, on behalf of Mr. Kalbaugh, I would assert to the court, the trial court's order in this case clearly said and has been characterized by the court as a final and appealable order. So this is not premature. As a matter of fact, had Mr. Kalbaugh attempted to appeal the August 26, 1996 decision at that time, his appeal would necessarily have been dismissed by virtue of the authority of this very court in its decision of Wilson versus Wilson. And you may find that reference more specifically in Mr. Kalbaugh's reply brief on page 8, and that would be under footnote 2. Your Honors, it has also been suggested that there is a doctrine of plain error that may or may not have been missed here. While I believe that this doctrine is unnecessary in order to decide this appeal, if the court is inclined to consider the plain error doctrine, the trial court clearly, plainly erred. Certainly, a court commits prejudicial and plain error when it issues a judgment and order without having jurisdiction to do so. And that is precisely what happened in this case. More specifically, I would refer the court to the appellant's reply brief at pages 9 and 10. I think, Your Honor, with that, I will reserve my time for rebuttal. Thank you.
May it please the court. I'm Melissa Graham-Hurd. I have the pleasure of representing Deborah Kalbaugh, who is here in the courtroom with us today, regarding the enforcement of her divorce decree. As you are aware from reading the briefs, William and Deborah, after a 16-year marriage, were divorced in 1995. In 1995, people who were members of defined benefit plans from the state of Ohio, as was and is Mr. Kalbaugh, any defined benefit plan could not be divided pursuant to QDRO because QDROs only applied to ERISA pensions and not to state pensions. Judge Nicely from our Summit County Court was at the forefront of those judges trying to make a difference for litigants in front of their court who either had to have an estimated value of the pension, and if they're going to keep the pension, then they had to give up everything else and then make more payment. It just didn't make sense for them, for those judges, to not issue QDROs. So Judge Nicely, in her proactive way, issued an order in 1996 which was called a Qualified Domestic Relations Order, which was, of course, promptly ignored by Ohio Police and Fire because it did not have to comply with QDROs because they applied to ERISA. And, of course, the Ohio Police and Firemen's Pension Plan is a statute-created entity. It wasn't until like-minded judges in various different places in Ohio, including Cuyahoga County, which then was appealed up to the Supreme Court at least twice. Finally, in 2001, I think May of 2001, the Ohio Supreme Court held in the Erb case that pensions by state employees earned during the marriage are marital property and should be divisible upon divorce, like any other defined benefit plan. And then in 2002, division of property orders became the law with an addition to the Ohio Revised Code. So in this case, where OPF ignored the 1996 order, which still, by the way, bound the parties to do things, amongst things, William was bound to make payment directly to Deborah when he began receiving payment. He has failed to do so. This woman has been waiting 22 years and received nothing. But a deferred benefit is part of the defined benefit plan circumstance. You pay into a pension fund, or your employer does, and then you wait until you get service or age eligibility, and then they start paying you out monthly. The distribution of pensions earned during the marriage usually takes that QDRO. But in this case, there was language in their decree that, we have a fundamental difference here. We do not believe that the 96 order in aid of execution varied from the language in the decree. There's no dispute that an order in aid of execution of a decree cannot change the terms of the decree. If you look at the language used in the decree, it talks about the values, the estimated values of the Social Security, of the OPF at the time of divorce. Now remember how things were done in 1995. We had present value calculations so that things could be offset. The value of the house, the value of the bank accounts, the values of the cars, everything else went to the non-state employee in order to balance the equities between the parties. So the values, the present value of the pension, the present value of the Social Security, as stated in the decree, were based upon hypotheticals. What they did was they based on an assumed high 3 years, which is part of the calculation when a person retires, and assumed that high salary for those high 3 years based on assumptions on how many more years the person would work under the system, based on the number of payments that the retirement would take from the time of retirement until death, adding up all those monthly payments and then bringing it back to a present value.
So this is what pension evaluators did?
Yes, sir.
95.
Yes.
And you
that's-
reached an agreed amount of $57,000 after the set-off of the wife's Social Security.
Yes, which was again an estimated hypothetical amount.
But where does it say it's an estimated hypothetical amount?
That's how the present values were done.
Is it anything in the record that would indicate that?
Not to my knowledge, Your Honor. When we look at the argument that's made by Attorney Trilla about frozen benefit versus coverture benefit, I don't think we're there yet, but just in case we are, in case you want to entertain that argument, if we look at the language of the decree, we don't see accrued as of date of divorce. We don't see she shall get X number of dollars. We don't see that. We don't see a cutoff date. We don't see a bright line. If you look at the line of cases that differentiate between the coverture method evaluation, which is, we think, the only fair way to do that, but for the early years in the plan, the marital foundation theory, any benefit increases in the value of the plan from the date of the divorce until the date of actual receipt of benefits are built on a foundation made during the marriage. But for those first 16 years, he would have had to start all over again. So the frozen language, it's not there. It's not, there's no language stating that the coverture method is inappropriate. The values stated are only estimations. The argument about COLA, that's a function of state law. When COLAs came in the revision of 2005 versus 2002, enabling legislation to allow state pensions to be divided, that's when COLAs came around. Pre-retirement survivorship annuity is still not available under the state plans as they are under ERISA. So 22 years, and then the complicating factor is that Mr. Kalbaugh entered into the DROP program. Under DROP, a person is retired, enters into DROP for at least 3 but not more than 8 years, where they continue to work, and then their monthly contribution, instead of going into the regular OPF fund, goes into an account that they, after 3 or 8 years, can start drawing upon. So when he invested the amount of his defined benefit plan, he was investing hers too. And her share grew over that period of time. What it is, we still don't know. We don't know. The order in June of 2016 only did a couple things. Ordered him to sign an authorization release. We don't know. He has steadfastly refused to cooperate in providing any information.
Can't you get that through court order?
I'm sorry?
Can't you get that information from OPF through a court order?
We can.
Did
We
you try
can.
that?
Once this court gives jurisdiction back to the trial court level, if Mr. Kalbaugh still refuses, the court can order that it be released.
But that hasn't happened up to this point.
Hasn't happened yet.
Have the parties tried to mediate this?
No. No, they have not.
No, we had mediation through the Court of Appeals.
Good to know.
Is that something?
22 years is a long time to wait. You know, my client is willing to do whatever she can in order to end this and start the retirement benefits flowing her way too. Apparently, Mr. Kalbaugh has been taking a retirement benefit for 3 years. And
Schaefer, how would they get to mediation if they were interested?
After we're finished with today's argument, we can have something that you're interested in doing. If you're not, that's fine. We'll take that under advisement and see what happens.
as we stand right now, we only have an authorization order. We have a DOPO shall be prepared, the terms of which have not yet been determined, whether it's frozen or coverture or a money amount or a percentage. We know it's going to be less than 50 because of the Social Security offset. You can't be appealing divide the cost of DOPO equally because that was part of the original order. Is he appealing the motion to dismiss? No, because it's ongoing. And the order also awarded her no attorney fees and her having to bring 20 years later and an action to enforce the rights that should have been hers in 1995.
Counsel, if I could, I'd like to go back to something you said very early in your argument.
Yes, Your Honor.
When you were giving a little history and about Judge Nicely, and while I respect her acting, I mean, your words were in her proactive way, you tell me what legal authority there was to enter that 1996 decree?
As it turns out, none. But
Does that cause you a problem?
no, she didn't have authority over OPF, Ohio Police and Fire.
That I guess.
They were not ever joined as parties. Many courts tried to join the state plans as parties, and they steadfastly refused to be part of it. The Ohio Attorney General was involved in a lot of cases and whatnot. Judge Nicely did have authority over the parties and did make a valid order over the conduct of the parties and how they were to carry out the provisions of the decree. She did have equitable powers over the parties and
I was
exercised
referring
them
to the
properly.
parties, not the pension
Yes,
system.
and the pension plans, they were very slow, especially the uniform services. OPERS and STRS and SERS were very cooperative at the very beginning, but the uniform services State Highway Patrol and OPF were not willing to negotiate with even the Ohio Domestic Relations Judges Association in trying to solve the problem and work the problem so that equity could be done to parties to a divorce, no matter if they were private employees, state employees, to treat all people the same, no matter what their circumstances are, in dividing the assets that were acquired during the marriage, just like anyone else. So within that context, yes, she was acting within her authority, but no, she couldn't bind OPF any more than the judge in Cuyahoga County who sought to join OPF in the Erb case, which later in 2001, in May of 2001, the Ohio Supreme Court finally said, yes, state pension plans should be divided, divisible, just like ERISA plans. And then the Ohio legislature began to work. And then all 5 of the state plans got on board. And then they did their, still very narrow, and not the same as ERISA, DOPO form, which must be filled out exactly the way that it is. Thank you, Your Honor.
Quick question, was there a hearing before the August 96 judgment entry?
Not to my knowledge. I think that was just a paper entry that was,
That's how I recall it. Just
That
want to make
was-
sure I understood that correctly.
yeah, prepared in accordance with the decree. It looks a lot like Qdros did during that period of time for other plans.
Okay, thank you.
Thank you, Your Honor.
Thank you. Rachel, you have 8 minutes.
Thank you. Your Honor, let me start with the notion that this case is not about the history of a division of property order. This is about an order from the trial court in 1996 that without question modified the decree of divorce, and the trial court had never retained jurisdiction to do that. Now, you have heard this is this is simply an order in aid of execution. That's absolutely incorrect. And I can tell you how we know that. This very court decided George versus George, which was referred to in the appellant's brief at length. And you can find that at pages 16 and 17 of the opening brief. This court issued a decision returning a case to the same Summit County Domestic Relations Court for having modified its divorce decree subsequent to the divorce without having retained jurisdiction. In that case, a QDRO was prepared, a Qualified Domestic Relations Order, and it was approved by the trial court, but it differed from the divorce decree in that it added additional interests to the spouse that were not part of the decree, much the same as here. In that case, a coverture fraction formula was used to determine the kind of benefit that would be paid in the form of a monthly stream. However, the divorce decree said that the benefit was the exact amount that you could divide as of the date of divorce, just as we have here today. The next thing that QDRO did was to add cost of living adjustments. It also then improved the QDRO by adding investment gains and losses. This court, this 9th District Court of Appeals, sent the case back to the Domestic Relations Court and said, you cannot make those additions to your divorce decree without having retained jurisdiction. Exactly what we are talking about today. The judgment entry that was entered in 1996, which Your Honor was correct, was without authority for the judge, was to specifically add features to the divorce decree that never existed. Let's remember, this divorce was not the consequence of a trial. This was an agreement between the parties. And they agreed not only to the fact that there would be a division of marital assets, but they agreed to the specific value of each and every one. If you go back to the divorce decree and look at the judgment entry, the court actually did the arithmetic. That's how we know what the number was. That's how we know that when the the qualified domestic relations order was finally entered in this case, that's where the number came from. And so, Your Honor, the fact of the matter is that this is a situation very much the same as this court's decision in George versus George. And I would say that we heard a reference to the drop account. Those are clearly all post-decree benefits. Mr. Kalbaugh had already been divorced, he had already retired, and then he was rehired as a consultant under state funding, and as a consequence, earned additional benefits through drop. But by that time, he was long divorced and retired. Now, you've heard that, well, Mrs. Kalbaugh has had to wait for 20 years to get her benefits. That's not a consequence of anything Mr. Kalbaugh did. The benefits were never available until he could receive benefits. And that wasn't until essentially 2013, at the end of 2013. And what happened thereafter is immediately at that point, Mrs. Kalbaugh applied for her benefits. And if you check the record, you will find that the qualified domestic relations order that was entered on April 28, 2014 was approved. And Mrs. Kalbaugh applied for the benefits, and if you look at the record, you will see that the payments were made, and I believe it was May 1st of 2014. And those payments that were made were the exact amount that was agreed to, and that you can go back and do the arithmetic in the divorce decree. It's precisely the same. So, as I said, Your Honor, I think that the end result of this, if you go back and look at George versus George, you'll find that that authority will tell this court that the trial court's August 26, 1996 judgment entry was void. And as a result, the result of the issues of the judgment entries from January 19, 2016 and June 3rd, 2016 would also have to be void and unenforceable because they're based on a void judgment entry. With that, Your Honor, I will entertain any questions. Otherwise, I would ask the court to grant the relief being requested by the appellant.
Just out of curiosity, when the wife applied for and received her benefits in May, that was pursuant to a...
Qualified domestic relations order that was entered on April 28, 2014. That order was originally entered on April 1st, and the state fund wanted to make a correction. And so the entry finally went into effect, and as a result, the funds were made available immediately. And they were collected to the penny.
Thank you.
Thank you.
Thank you for presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted to our website and that of the Supreme Court.
Thank you.